You know, sometimes the simplest things can cause the biggest problems. Today, we're going to talk about a story that starts with something pretty normal. A guy just wanted to give his house a fresh coat of paint. But that one decision, it ended up spiraling into this massive legal showdown with his homeowners association. It's the classic tale of a homeowner versus the HOA, and we're going to get into exactly what went down. So this brings up a huge question, one that millions of homeowners have probably asked themselves at some point. Can a committee of your neighbors really tell you what color your own house has to be? And can they legally force you to change it? Well, this whole explainer is going to dig into the real-life case of Jerry Grossman versus the Gainey Ranch Community Association to find the answer.
All right, so let's set the scene here. On one side, we've got our homeowner, Mr. Jerry Grossman. On the other, his homeowners association. And the thing that sparked this whole fire? A new coat of paint on his house and a newly painted dark brown front door. That's it. But to the HOA, this was a major violation of the community rules.
Now, what's so interesting here is that this wasn't just a one-way street. It wasn't just the HOA coming after him. Mr. Grossman actually filed a petition first, saying the HOA was totally out of line trying to make him repaint. And then the association filed its own petition right back at him, saying he made changes he wasn't allowed to. So the judge just rolled them together into one big case. Okay, so to figure out who was right and who was wrong, we have to do something really important. We have to understand the rules. You see, in a planned community, an HOA doesn't just get to make stuff up. Their power comes from a set of legal governing documents. And the most important of these documents are the CC&Rs. The best way to think about these is like the Constitution for a neighborhood. Seriously, they're legally binding contracts that every single person agrees to when they buy a house there. And their whole purpose is to keep things uniform and protect property values, covering everything from your lawn to, you guessed it, the color of your house. And this right here is where things get, well, a little complicated. See, Mr. Grossman lived in a smaller community called the Greens, and it had its own little committee. But the Greens was just one part of the much larger Gainey Ranch Association, which had its own more powerful committee, and that top-tier committee had the final say. This two-level system is absolutely critical to the story. And look at this. This one sentence, pulled straight from those CC&Rs, is basically the star of the whole show. It says that any change that alters the outside appearance of a property has to get prior approval from that main top-level association committee. You gotta remember this rule. It's everything. All right, so with that big rule in mind, let's put ourselves in Mr. Grossman's shoes for a minute. He genuinely believed he was doing the right thing, so where did it all go off the rails for him? So here are the facts from his point of view. He repainted his house, which was pink before, to a color called Sterling Place. And his logic was pretty straightforward. His house is made of stucco, and he believed Sterling Place was an approved color for stucco. Simple enough, right? As for the front door, he basically said, hey, I looked and I couldn't find any specific rules about door colors. And here's the kicker, the detail that really made things confusing. That local committee I mentioned, the Greens Committee, they had actually approved Sterling Place for buildings in their little area. They were even on his side in the dispute. So you can totally see why he would think he was in the clear. Okay, let's flip the coin. Now we're going to look at this from the Gainey Ranch Association's perspective. For them, this was not about whether they liked the color brown. For them, this was all about following the procedure laid out in the rulebook. This slide just nails the core problem. It was a total clash of interpretations. Mr. Grossman was focused on the thing, the color, the material, but the association was focused on the process. They were basically saying, we don't care what color it is. The rules say you have to ask us first for any change, and you didn't. So the association laid out its evidence. First, they said that, yeah, Sterling Place was an approved color, but only for things like interior entryway walls, not for the whole outside of a house. Then they pointed right back to that critical rule. Any exterior change needs approval. And they argued the front door is obviously part of the exterior. And finally, they noted the original doors were stained oak, not painted at all. So both sides have made their arguments. The hearing happens on April 24, 2008. All the evidence is on the table, all the testimony is heard, and it all comes down to the decision of one person, the administrative law judge. So before I tell you what happened, what do you think? Put yourself in the judge's shoes for a second. On one hand, you've got the homeowner who thought he was doing the right thing based on what his local committee said. On the other, you've got the main association sticking to the black and white text of the legal documents.
Who do you think has the stronger case?
Now, for the judge to make a call, they use a standard called preponderance of the evidence. This isn't like a criminal trial where you need to be sure beyond a reasonable doubt. No, here it just means the judge has to decide which side's story is more likely to be true. It could be 51 to 49, but that 51% wins.
And the verdict? It came down and it was decisive. The judge ruled in favor of the Gainey Ranch Association. Mr. Grossman lost.
So why? What was the judge's reasoning? Well, it all came back to the crystal clear language in the CC&Rs. The judge decided the association absolutely had the authority to approve colors. Mr. Grossman's whole argument about the stucco didn't matter because the rules are clear. A house has to stay the way it was built unless you get a change approved first. The association proved their case. Mr. Grossman, well, he didn't.
Now, this ruling wasn't just, a symbolic victory for the HOA. It came with some very specific and pretty expensive consequences for Mr. Grossman. The judge laid out 3 things he had to do, and he was only given 60 days to get it all done. First, repaint the entire outside of the house with a color the association actually approved. Second, get that front door back to a stained oak finish. And third, he had to pay the association back for the cost of its legal filing fee. And just that filing fee alone was $550. That's before you even think about the cost of hiring painters to redo an entire house or a craftsman to strip and refinish a front door. That is a very, very expensive lesson. At the end of the day, this whole entire fight really just boils down to one simple takeaway, which we can frame as a final question for every single homeowner out there. If you don't read the rules, do they still count? Well, in the eyes of the law, the answer is a big, resounding yes.